We'll get started. And panelists, if it's okay, instead of going like this, I'm going to go around in a circle so everybody has opportunities if time runs out to answer questions correctly. That's okay? I'll just do circle. It's all right. I'd like to welcome everybody to this this panel interview. My name is Stubbs. I'm moderating. As a moderator, it's my job to make sure that the rules are adhered to, and as well keep track of time so that we can do this all efficiently. I will not be asking any questions, but I will be directing questions and moderating this panel interview. I would say at the very beginning, please no personal attacks on any candidate. That's from both the panel and from the candidates. This is a panel interview, and I can tell you that any personal attacks will count against you. It's not something that we want to hear. We'd rather hear your qualifications than you trying to disparage somebody else. If there is any negative comment about a candidate, at my discretion, I can give that candidate some time for rebuttal. I hope I don't have to use that. The interview will go as follows. There will be a 1.5-minute introduction by each candidate, after which we'll open up the questions for all the time that's allowed. Up to 30 seconds for each question. They can either be directed separate questions at two individual candidates or a general question given to both candidates. And each candidate will have 1 minute to answer, and there will be no follow-up questions. Please be good with your questions because you do not get a follow-up. And so with that, I would like to start Judge Earley. You'll have to forgive me that I don't call you honorable because I don't want to infer that the other candidate is not. So Judge Earley, if you could start with your 1.5-minute introduction, please.
Yes, my name is Kerry Earley. I am a judge in Department 4. I was appointed by Governor Sandoval in July of 2012 after going through the Nevada Judicial Commission process. And there were 20 people in that process. I then had to run in the November of 2012 election, and I had one of the everybody will remember that was here before, weirdest elections. I had 7 people against me on a general ballot. I don't want to explain how it happened, but that's what happened. I did win the November 2012 election, and I've been on the bench then since July of 2012. I am in Department 4. Department 4 is in all civil litigation, and that's based on my background. I was raised in Kansas City, went to law school in the University of San Diego, and met a partner in a law firm in Las Vegas named Walt Cannon. I wanted to do litigation. There were very few females at the time, and so he offered me a chance if I would come to Las Vegas and do litigation. And my parents said, go ahead, give it a try. I really didn't know people lived in Las Vegas with families. I have been here for over 32 years, as Cheryl Gardner knows, as my court reporter for many years. So my background is in civil. I did complex litigation. I started out in the MGM fire. So don't ask me how old I am, it's quite obvious, because I was right out of law school. I became a partner, started my own law firm in 1993, Earley Dickinson and then Earley Savage.
Time, please.
Department 4 is all civil, and that's my experience.
Thank you. And we'd ask that you respect time if time isn't. Thank you very much. And Mr. Smith.
Good afternoon. Thank you, all of you, for giving up a sunny, gorgeous Saturday in Las Vegas in the 70s. It's soon going to be history for us, right? I'm Steve Smith. I'm the challenger in District Court Department 4. I've been an attorney 35 years. I consider myself top of my game as a lawyer. I graduated from Rutgers Law School. Right after law school, I went to the Attorney General's office in New Jersey. I'm also a former federal OSHA prosecutor, where I prosecuted all types of cases, including fatalities in Region 2, New York. I got even more anxious for the courtroom, and I moved to Phoenix, Maricopa County, where I was a deputy county attorney. I was a prosecutor for 4 years, went as high as second-degree murder cases, and then I was also a deputy public defender, so I've had that experience of representing indigents accused of crimes. After playing cops and robbers, so to speak, I then went into a civil litigation firm that brought me to Las Vegas. I took the bar exam. I represented the Las Vegas Visitors and Convention Authority in many casinos. Wound up moving up here. I got a job as an attorney for Nevada Power Company. And everybody thought, oh, you work for the power company. You working on rate cases? No, I did litigation. The power company got sued a lot. Argued 6 cases before the Nevada Supreme Court. After the power company, I did some state service.
Thank you very much.
Okay, sorry.
Now, I would, one note, Ms. Cheryl Gardner is a panelist here. However, she is recusing herself for this particular race as well as the Department 3 race because she does work as a court reporter in those courts. She will not participate in the panel, nor will she participate in the vote. So now if we could start with Ms. Bosley. Ms. Bosley, do you have a question for the candidates?
Good afternoon.
Good afternoon.
Okay, Judge Earley?
Early, right.
Okay, hi. What do you see as strengths and weaknesses of the district court? And describe some changes that you would like to see made in the district court.
While I've been on the bench, I think our biggest problem is efficiency because we have such a heavy caseload. I have over 1,300 open cases, and my cases, as I said, are all civil litigation. And in addition to my open caseload, I have also been given medical malpractice cases to try because of my background in doing medical malpractice for over 30 years. So the hardest part to me is the efficiency. And so what I have done is I have set calendar, and some attorneys don't like it, but at 8:30 in the morning because I can get so much more done, and I do easier things, status checks, smaller motions, ones that aren't quite as opposed. And then I have a 10 o'clock calendar, so the other ones that go to the 9 o'clock calendar for the other judges, I then have them come to my courtroom at 10. The other thing I have done to try to make it more efficient is if there's a chance that they don't have to court like on a status check, I will talk to them and say, I will put you down for a 90-day status. Sorry.
No,
This is
no,
very hard.
No, you did very good.
It's very
I said
hard
time
to
and you
limit it.
stopped. That's what you got.
I feel like I'm
is
at the
that question
Supreme
also
Court. I
for-
need the red green light.
I'd like to ask Mr. Smith, based on your experience, and you have over 35 years total experience, what do you believe would be your most important contribution?
Because I have both the civil and criminal experience, I consider myself to be ambidextrous. I can handle both civil and criminal cases. One week I could do a criminal calendar, one week I do a civil calendar. I didn't get to finish, but I've been an arbitrator for over 17 years in the court annexed arbitration system, a short-term trial judge, among other things, and I would bring alternative dispute resolution. I mean, it's absolutely correct that there is just so many cases. More emphasis needs to be placed on not just giving people their day in court, but seeing that justice is done and getting the parties together to get these cases resolved. It's so expensive for litigants to bring these cases to court. It's such an enormous burden, and if they can get the parties together and get them talking and get them to resolve their issues, I think that will make the system more efficient.
Thank you. Okay, Ms. Karen Steele.
Good afternoon.
Good afternoon, everybody, and thank you for joining us here today. And I allow us to scrutinize you in public in such a manner. My question is for Mr. Smith. Obviously, you think you have something greater to bring to the department as a challenger to Judge Earley. Could you please describe briefly what you think you have to offer that is so much greater?
I repeat what I said earlier, is this, I am ambidextrous. I point out that the voters are going to be the one that are going to decide this race. And in the last election, my opponent had actually 8 opponents, and she only polled less than 20% of the vote. And so based on that election result, I think the voters deserve a choice, and I'm going to give them that choice, and they need to decide, you know, one-on-one between candidates who is going to be the judge, because we're not going to have judicial elections in district court for a long time.
Thank you.
Is there another question, Ms. Steele?
No, thank you.
Okay. Ms. Knight. If someone could pass her the microphone, please.
This question is for both candidates. But I would like Mr. Smith to start off first, but we're going to I want to talk about the efficiency. We were talking about efficiency to kind of piggyback off that, but the back end of being a judge, how would you approach being efficient with having a large caseload, pleadings, a staff, and how do you go about that to keep it perfect? Because I know a lot of attorneys sometimes scrutinize judges for not reading all the pleadings. Some don't even mind. So really, how do you stay involved in the community? How do you do everything and be efficient on the back end? So how would you approach it, and how do you actually practice that on a regular basis?
Well, I've been down in the trenches, so I kind of see how it operates from the outside working in. You have to read all the pleadings. You have to be a good listener as a judge. And the most important thing, I think, that the attorneys criticize judges for is you have to be decisive. We pay judges to make decisions. Make a decision, that's it, move on to the next case. So everybody who wants their day in court gets their day in court. There's nothing worse than going to court and it's packed with attorneys because they've been back and back and back on the same motion, application, whatever, and there's been no decision made. Decisiveness is key. That's what we pay judges to do.
Well, I am on the bench and I am decisive. What I have done to be efficient, I don't take things under submission. What I do, the only time I would do something like that is if they come with a new argument and new pleadings that, they filed at 5 o'clock the day before the hearing. And then what I do is I then continue it because I want a chance to read everything. I will not get on the bench unless I read everything. And because I have complex civil litigation cases, my background in it, and just since I've been on the bench, I'm seeing more and more issues over and over. Like right now, I'm in a major products liability case. I now know federal preemption. I now know, whether it's a defective product or not. I now know whether we can do FDA. There's so many things you learn from the practice as the more you do it in complex civil, which is what my department is, and what it is staying, especially since Judge Earl, I don't know if you know, is retiring, and he was the only one on the bench who has complex civil litigation like I do, my experience before I got on. I'm more efficient.
Thank you very much.
This is really...
Ms. Daywood? Everybody's giving the same amount?
I know.
Yes?
This question is for both candidates. Do you ever wake up in the middle of the night thinking about a case wishing you had done something differently? If so, can you please describe one situation?
Can we start with Ms. Earley?
You know what? I haven't awakened in the night wishing I'd done something different, but I'm in a trial right now. I wake up about what I don't have done, dreaming about jury instructions. That is a little scary. I think I'm living it too much. But I have, you know what? I make a decision. And here's what I learned in judicial college, and which was so different from private practice, because I'm an AV-rated attorney. I zealously advocated for all my clients for over 30 years. But I learned at the end of the day, 50% of the people think you're wrong, and the other 50% think you didn't give them enough. And so I have learned, I analyze everything, and I explain to them. In fact, one of the things I've done in oral argument, when I get the look, which, when they're not winning, I'll say, all right, what part of my analysis do you not agree with? And they'll look at me and they'll go, well, we just don't like the result. I go, well, I can live with that. If you cannot find flaws in my analysis and how I'm applying the facts to the law in this case.
Thank you very much. Mr. Smith.
I think you have to go through a deliberation process where you deliberate. I mean, I do this as an arbitrator. I go back and forth after I hear a case, and I go back and I read the arguments and the pleadings and the deposition transcripts. And very often I'll ask for supplemental argument. I have changed my mind as an arbitrator, but once I make that decision, I sit down and I write an order. And that's what, judges do. They get to decide things, and you have to make up your mind at some point and get it done. Or as Larry the Cable Guy says, get her done.
Thank you. Ms. Moore.
Lada. My husband's here now, so we have to say Lada. My question is directed at Mr. Smith. Lawyers are pretty much always unhappy, and Judge Earley's managed to
have a pretty high retention rate in the last RG poll. So, and given the fact that this is a civil, mostly civil department at least now, I guess why this department and why now?
Well, I go back to the election results. Less than 20%, less than 1 in 5 voters, even though she was running as the incumbent, voted for her. 3 of her main opponents outpolled her 2.5 to 1. Last time I checked, we have election of judges, and the people decide. And I wanted the people to make a decision here. I think I can bring some qualities, such as being able to handle both civil and criminal. There's no prohibition against this department. Assignments change year to year. Cases are always reassigned. And I think if judges are ambidextrous and they're not just from one field or the other, that leads to further efficiency.
Is there a question for
Yeah,
Ms. Earley?
I don't want to do follow-ups.
Okay. Ms. Alicia, greetings.
Hello. So I like that response to your oral argument, Judge Earley, about what part of my analysis you disagree with. Judge Smith, how would you respond to this type of situation? Do you consider yourself pretty confident in your ability to judge and deliberate, or do you kind of feed off of people's body language and respond accordingly?
Well, thank you for calling me Judge Smith. I'm not a judge yet, but I hope to be one on November 5th. Yes, I mean, you bring your experiences with you. You do look at the body language. I read everything I can about body language. I mean, we do get certain instinctive gut feelings about when somebody's trying to pull the wool over your eyes. And, you know, it's much easier to be an advocate, I think, than to be a decision maker. Because when you're an advocate, when you're an attorney, you're advocating a client's position. And some lawyers do it very well, but you have to know the difference between the slough and the meat on the bone, and what's a genuine, good, sound legal argument. And every day there's probably a lot of unsound legal arguments being made. And that's why I think, you know, if I become a judge, or when I become a judge, I'm going to hire a law clerk that has experience, that can read the papers and sort of recommend, you know, right off the bat, this is a nonsense argument, Your Honor. You know, take a closer look at it, so you can agree with me.
Was there a question for Ms. Earley? Okay.
Follow-up?
Ms. Carroll?
I have 2 different questions, one for each candidate. One for the Judge Earley. When presiding over a case, how aware are you of the issues that are potential appeal issues in a case, number 1? And please give me some examples of issues that you feel should not be appealed, and why.
Well, every time I make a decision, every time I review any matter, I always do a record because everything is a potential appeal. I'm in trial right now. We're making records just on the cause challenges for the jury we're doing. So I'm very cognizant as a 30-year litigator, litigating many, many, many cases here in Clark County, Nevada. I'm very aware that everything's an appeal issue. In fact, there's a new Nevada Supreme Court case that chastised judges who didn't make a record after being up on the bench. So like in the products case I'm in, and all the other trials I've done, at least 15 since I've been on the bench, I'm very aware that both sides have to make their record. That's one thing I'm very cognizant of, and that's one thing I was very cognizant of as a trial attorney, because I did major civil litigation. So I really truly feel, as having 30 years experience doing complex civil litigation, that makes me understand what it's like to be in the trenches.
Time,
And
please. Thank you.
I have something for you, Mr. Smith.
Different question? Okay.
Okay, the question for Mr. Smith. What has been your most successful case to date in the state of Nevada? And please give me at least 3 specific wins.
Okay, well, my most successful case was a case called Haggerty versus Nevada Power, which dealt with the dreaded workers' compensation immunity of employers. It's an obtuse legal issue that's hard to explain in 90 seconds, but it was basically somebody that got into some electric facilities and got injured, and it was the employer's responsibility that it occurred. Generally, in workers' compensation, the employer is immune, but to keep employers from violating rules like the 10-foot rule or causing an injury, you want to be able to pierce that immunity, and it causes people to be safer. Just like Judge Earley mentioned, she's doing a product liability case. You know, if people have warnings or they test products, we're going to have safer products. The same thing is true if employers have to undertake certain steps to do things. We're going to have a safer workplace, and we're going to have, you know, fewer workers' compensation cases.
Time. Thank you.
Yes, good afternoon. Thank you for showing up for a panel, subjecting yourself to our questions. Considering the courtroom that you sit on, I'm just going to ask a basic question for you, and that has to do with our community itself, because as judges and attorneys, you're part of our community, and it seems that a lot of people get disassociated from, let's just say, the common people in the community that don't have such prominent positions in the community. How do you feel you keep yourself grounded within our community, and what do you do personally outside of your already hectic schedules to keep yourself grounded within our communities here?
I'm going first. What I have done is try to keep up with the different activities I did before as best I can. It all depends on your trial schedule, as you know, but I was very actively involved when our children were growing up in youth soccer, and I still try to do things in that. My mother had breast cancer, and I'm also a survivor of breast cancer, so I'm very, very active in the Susan Komen I Walk for Life. I wear the survivor t-shirt, so that is one area. The other area I try very hard to is to get out. Like Veterans in Politics had a wonderful event at a high school where they got to meet the judges, we got to speak, they got to see that judges are human beings, their wives, their mothers, you know, they go to soccer games, they do all the things that, you know, they do, and that we were approachable. Events like what Veterans in Politics did would very much help, because it was on a Saturday morning, and the district court judges were thrilled to be there. It was a great opportunity to intermingle with the students.
Mr. Smith.
I take joy in getting involved in bar activities. I've been on the editorial board of Nevada Lawyer since 1997. I was on the CLE committee for the state bar. I've written extensively. I just did an article on gun laws and gun restrictions. I've written about Nevada's lemon law, a consumer issue dealing with what happens when you have a defective automobile and it's not taking you where you want to go every day. How do you enforce the lemon law? How do you collect on it? I enjoy lawyers in the legal community, and I like to be a part of it. And it's nice to be in a setting where you're not contentious and in litigation. The camaraderie is terrific.
Thank you. Ms. Dupre. Did I say that correctly?
Dupre is the right pronunciation. Two-sided question, and kind of following up on Mr. Brooks' question. How has becoming a judge changed your life toward your family, friends, and the community? And Mr. Smith, have you anticipated changing your life if you were to become judge?
My life has changed because it's a different world being a judge than being a litigator for 30 years. I actually have the opportunity to give back to the community, and I love it. I actually feel this is a culmination of all the hard work I did for 30 years representing clients and being down in the trenches, that I can give back. That has changed my life. I just had a jury panel, and we're picking a very long jury for almost 3 months. It is very hard to ask jurors to take out of their life, as you can imagine, for $40 a day to sit through a case. And I spoke with them, and I really felt very great. I said, there's so many freedoms in this country, but there's two civic responsibilities we all have to do as Americans. We have to vote, and we have the privilege of doing jury service. So for me, I've been blessed. I truly love what I do. I truly feel like it's an honor to be on the bench.
Mr. Smith.
Well, I think one thing, when you're a judge, you're a public servant, and you're going to be under the watchful eye of everyone. So that's obviously going to be changing my life in terms of who you associate with and what you do after work. And not that I don't lead a clean life as a Boy Scout, but I think you have to be a little more circumspect and to be more careful with the company that you keep. So I think it changes that way. In terms of when you do a jury trial, I think it's always important to allow the lawyers and the parties, if they want and if the jury so wants, for that jury to get polled and to get asked questions. I mean, some jurors don't want to know. They decide the case they want to go, and that's it. But I think it's so important for the community to understand when they ask fellow members of the community to serve on a jury, what was their impressions of the legal system, the case, the parties, kind of give them feedback, because that's the most important thing.
Thank you. We have gone through the entire panel very efficiently. Thank you so much for being here. Thank you for answering our questions.